have already stated that law flows from authority through the channels of the sources of law. Now we must address what happens when the authority expresses itself in ways that are contradictory. In practice, lawmaking is copious. For any given country, there are hundreds of laws promulgated each year and thousands of law enforced. In the common law jurisdictions, there are thousands of cases decided each year. It is almost impossible to promulgate a new law without stepping on the toes of prior existing rules. This makes it very much possible that normative conflicts may arise. When a variety of normative instruments demand different things, and it is not possible to honor all of them, we speak of a normative conflict. The question is then, how are these conflicts to be resolved? How do we pick which rule to follow? Note that making this decision is crucial. If I can just capriciously pick which one rule to follow, the idea that one is operating in accordance with the law goes out of the window. If it's a matter for me to capriciously pick one of these conflicting rules as the one to be obeyed, there is no rule of law anymore. So we're going to address ways in which these conflicts can be solved. At the moment, we're not discussing interpretation. We're not going to assume that the conflict is merely apparent, that we have just mere miscommunication, and that once we get the language right, the conflict disappears. We're assuming that we have here true bona fide cases of normative conflict. We're going to start by looking at how to solve conflicts in legislation. There are three principles for solving conflicts in legislation: lex superior, lex posterior, and lex specialis. These principles are to a large extent self-explanatory and perfectly logical, especially the first two. It is hard to imagine how any system of rules could exist without them. Lex superior simply states that if we have two conflicting sources, the higher one must be obeyed. So if the constitution of your country says that suspects can be detained for investigation for a maximum of 5 days, and the Code of Criminal Procedure authorizes preventive detention for 30 days, the Constitution as the superior norm overrides the lower norm, in this case the Code of Criminal Procedure. Lex posterior simply states that if you have two rules with the same authority or the same rank, the later one applies. So for example, if same-sex marriage was declared illegal in 1990, but was declared legal afterwards in 2010, the rule of 2010 as the later rule is the one that has to prevail. The logic of this is pretty inescapable. If the former and not the later rule prevailed, it will be impossible for the legislative authority to change its mind. This would mean that it would be practically disempowered from the ability to create rules on a subject immediately after they first make a rule. This would be rather absurd, so we define that lex posterior must trump the newer rule must trump the older rule. The principle of lex specialis states that among two conflicting sources, the one that is more specific to the case at hand must be applied. So if I have a rule prohibiting theft and another one permitting theft in the case of hunger, and they have both been enacted in the same day, in the same law, let's say in the criminal code, in this scenario, the latter rule, the one that permits theft in the case of hunger, must apply, because it provides an exception to the more general rule. The general rule on theft has an exception for special cases relating to theft in the situation of hunger. Of all the principles, lex specialis is the only one that's not really crisp. Consider the following laboratory example. These two rules are promulgated at the same time in the municipal code. Rule A states, all dogs are prohibited from entering butcher shops. Rule B states, Guide dogs are allowed everywhere. So which rule is general and which rule is special? A first reaction will be that rule B is the is the special one because it's only for guide dogs. But note that we can easily turn things around and say that rule A is the special one because that one's only for butcher shops. That is to say, there's more than one way of being special, and each one of these rules is special in its own way. Contrast this with posterior and superior, where there's only one way of being superior and only one way of being posterior, which makes these other principles much more crisp and easy to work with. Because lex specialis invites judgment, you do need to provide more argumentation about why one particular interpretation of a special must be adopted in a particular scenario. What about case law? We have been told that in the common law, newer cases must always obey older cases. This is the stare decisis principle, and it seems to be a reversal of our lex posterior principle. Here we have a bias towards the old. At first glance, this will appear unworkable. How could the common law ever adapt to changing times? How could the common law ever correct bad decisions? Well, there's ways. The answer is that alongside the stare decisis principle, there are other principles granting much needed flexibility. First, the common law does not operate in isolation from legislation. Rules made under the common law can change when the legislation changes. Naturally, for legislation, even in the common law, the principle of lex posterior applies. Second, not all cases are of equal hierarchy. Higher courts can override the precedents of lower courts and therefore innovate or correct mistakes that have been made. To this we may add that the highest courts of the land can never really be bound by stare decisis. They can always change their mind. Third, the common law gives judges many tools to wiggle away from old cases, and to these we must now focus a little bit more in detail. The first thing that we have to know is that the common law distinguishes between the holding and the obiter dicta. The holding is the kernel, the core of the decision. Obiter dicta is opinions that have been said in passing. When the common law says that all cases are binding, this really refers only to the holding. Stuff that is said as obiter dicta, stuff that is said in passing, is not binding. So judges addressing new cases can dismiss certain parts of all cases by claiming that they constitute obiter dicta and not an element of the real holding. To give you an example of this, let me simplify a little bit a famous case in the US Supreme Court relating to the legitimacy and legality of the death penalty. In this case, you could say, if you read the case from a very abstract level, let's say from a Wikipedia level, the case will say, okay, now the Supreme Court found that the death penalty is unconstitutional. If you just stop there, it would seem very hard to make any change and then reinstate the death penalty, which would make it difficult to explain why America has the death penalty today. What happens is that if you distinguish obiter dicta and holding, you will see that while the case makes many general claims about the death penalty being legally problematic, its essential kernel is that the death penalty is problematic because it creates unfair discrimination. That is to say, because the mechanisms and process whereby the death penalty is applied unjustly target a certain minority with disproportionate emphasis. And then how could the death penalty be reinstated in a future case? Well, what happened in a future case is roughly that the states that had a problem in the past with the death penalty introduced new procedural safeguards to ensure that there was no bias against certain minority. And then when the new judges considered the case, they say, okay, the prior case outlawed the death penalty in general, but what is the holding? The holding is that they allowed the death penalty insofar it was discriminatory and biased towards a certain minority. That leaves the possibility for a new case to say, okay, now, but we must permit the death penalty because we no longer find that specifically that it is discriminatory. So there you have an example of a difference between obiter dicta and holding. By focusing on the holding, you reduce the scope of the precedent, and then you give yourself freedom to decide something different. In addition to the holding obiter dicta distinction, the common law also gives tools to judges that are called distinguishing and analogy. Judges can always distinguish new cases from old ones, and therefore give themselves freedom to reach a new decision. Distinguishing is a technique of legal reasoning whereby judges find that an old ruling should not be extended to a new case, because the new case adds new facts that demand different treatment. For example, there may be a general rule against trespass in the property law, by virtue of which it's illegal for me to enter your terrain without your permission. But let's say, as adapting a little bit the facts of a case called Ploss versus Putnam, let's say that there's a storm and a family needs shelter, and therefore they trespass in your property to find a shelter from the storm in the case of a bit of an emergency. Then the court may say, well, although it's been settled already that illegal trespass is prohibited, and if it happens there must be compensation, those rules of illegal trespass were not made for cases of dire need, cases of emergency. When the fact of emergency is added, we have reason to reach a different judgment, that the trespass is not illegal and that no compensation needs to be provided. The opposite of distinguishing is analogy. In analogy, judges extend an old rule to a new case. Here, for example, we may find that this case is a bit more fictional. We may find that judges could extend the idea of trespass of a physical property by analogy to the breach of privacy. The trespass of physical property, of course, is something that has been protected for centuries. And then as the new digital technologies arise, we may find the need to protect privacy. And if the legislature has not said anything about it, judges may say, well, by analogy, we can regard the intromission, let's say, of a hacker in your account and taking private information as being similar to the breach of private property, as the trespass of private property, and deserving analogous treatment, for example, the duty to pay monetary compensation. So backtracking a little bit, we can find in the common law something that is similar to the classic principles of lex superior, lex posterior, lex specialis. They're slightly different. So really, instead of lex posterior, we have something you could call case anterior. Now, the priority or under the stare decisis principle is for cases as they have already been decided. That's literally what stare decisis means, not as it has been decided. We still have a principle of case superior, analogous to the principle of lex superior, which means that higher courts can override precedents. And finally, we have something like a case specialis principle, where courts find ways to treat novel cases in novel manner by interpreting prior holdings in a narrow fashion or using the technique of distinguishing, whereby new cases are highlighted as reasons for differing treatment. Please note that this terminology, case anterior, case superior, case specialis, is not official terminology. I just made it up right here, But the point of making it is first to show you the parallel that exists between legislation and case law in the need of priority rules and the sort of things that works as priority rules. And I also use this terminology for heuristic purposes, because if it's similar, the one of case law, to the one on legislation, you will find it easier to remember. So, all right, that's good for this topic.